Good morning, Ms. Thompson.
Good morning, how are
And
you?
you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000.
Right from the start, we're looking at a DWI charge, 6 months in jail, or a $2,000 hit to the wallet. But here's the catch. Everything depends on probable cause, the key factor that determines if this case even has legs hold on tight, because things are about to get complicated.
We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am. Okay.
On April 21st, 2025, in Harris County, Texas, a law enforcement officer was dispatched in reference to a wrong-way driver and initiated a traffic stop on the vehicle described by the 911 caller. The law enforcement officer made contact with the defendant and the defendant handed the law enforcement officer an unopened alcoholic beverage. The law enforcement officer noticed the strong odor of an alcoholic beverage coming from the vehicle, and the defendant appeared unstable and fell against her car. The defendant stated she spilled a whole can of beer on herself earlier. The defendant's vehicle appeared to have fresh damage consistent with hitting a curb. Standardized field sobriety tests were conducted, where the officer observed 6 out of 6 clues in the HGN, 3 out of 8 on the walk and turn, and 0 out of 4 on the one-leg stand. An inventory search revealed 3 open and empty beer cans in the backseat floorboard and other unopened alcoholic beverages. The defendant considered 2 breath and blew .143 and .145.
That breathalyzer reading came in at 143 and 145, nearly double the legal limit. But here's the twist. The defense is gearing up to challenge the very basis of the traffic stop. This is where reasonable suspicion and probable cause step into the spotlight in court.
What did you say the stop was for?
The stop was for, there was a 911 call that stated there was a vehicle driving the wrong way and described the vehicle. The officer found the vehicle.
Driving the wrong way?
I'm not sure. When the officer found the vehicle, it was not driving the wrong way, but it matched the description given by the 911.
Right. Anyone can call and say anything. Did he view any kind of traffic infraction? I could literally call and say, hey man, state's driving nuts. Go get him. Right? I mean,
There's
Yeah.
no other
Okay.
traffic infraction.
Spencer, I'm going to find that there's no probable cause to go forward with your case. There's enough death and destruction on our streets. Now, play it safe. The last thing you need is to end up in a 6x9 because if you get into an accident, maim, kill someone, especially with alcohol in the car. Do you understand?
That warning from the judge wasn't just harsh words. It was a final notice. Driving drunk isn't just endangering yourself. It's a legal time bomb waiting to go off. And now the courtroom gears turn once more. Miss Rice, it's your move.
Boneheaded moves. Please. Thank you, Your Honor. Good morning.
I have an arraignment for Miss Rice.
Do you mind bringing her up?
Yes. I do believe PC has not been found or...
Okay. Good morning, Ms. Rice. Ma'am, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Thank you, Your Honor. On April 22nd, 2025, in Harris County, Texas, law enforcement officers were dispatched to a crash call and found a vehicle inoperable due to a collision and blocking traffic. The law enforcement officer spoke to a wheel witness who stated he observed the defendant in the driver's seat of the vehicle with the engine on and advised the defendant to turn the vehicle off and exit the scene. The law enforcement officer made contact with the defendant who was sitting in the driver's seat of the vehicle and observed slurred speech, moderate odor of alcoholic beverage, and glossy eyes. The defendant admitted to consuming 1 alcoholic beverage. SFST standard field sobriety tests were conducted. A 6 out of 6 on the HGN was reported, a 7 out of 8 on the walk and turn, a 2 out of 4 on the one-leg stand. The defendant refused to provide a specimen. A blood warrant was obtained and executed.
If I may, Your Honor, what the officers completely failed to leave out of their report is that the car was registered to the other person that was present. The other person had the keys on them. The other person admitted to driving. At the time of the accident, I'm not sure why they switched seats. I don't know. I do know the wheel witness came after the accident had already occurred. They had been waiting on a tow. If the officer would have done any due diligence in his research or questioning the other person. They may have been intoxicated. I'm not sure. He didn't even follow up with them. They openly admitted, this is my car, I'm the one driving. The officer made no attempts to remedy that situation or even mention that in his report.
Do you have any of that?
Your Honor, I would just say that, I mean, based on what we have in the DIMS, we witnessed put the defendant in the driver's seat of the car.
After the car was already inoperable. He didn't see her, he didn't see the accident.
Boom! Probable cause, confirmed even with a strong defense in play. Why? Because the threshold is low. It only takes a maybe that a crime happened. Guilt or innocence comes later at trial. But for now, the prosecution just scored a win on the paperwork front.
For cause purposes, we have a wheel witness that says they saw the defendant behind the driver's seat.
Of an inoperable car.
And a law
I mean,
enforcement officer saw
at the scene of the accident, right? I mean, if you have some kind of other evidence to show, I have to give them time also, you know? I mean, this is just,
Yes.
probable cause is a very low burden, right? So this doesn't mean that you're guilty. I mean, if that's in fact true, that's why we have trials, right? There's always two sides to the story. I wasn't there, you were there, you know what happened, I don't know. So that's something that you bring out in trial and you know, perhaps even before, if you show it to them and it's in fact true, then, you know, they'll kick it. But I'm gonna find that there's probable cause to go forward with your case for now. Ms. Rice, any prior DWIs?
No, Your Honor.
License?
Check on the license right a second.
Like I said, I'm finding probable cause. I'm warning you not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, I will revoke your bond and put you in jail. You understand? You're not allowed to drive unless you have a valid Texas driver license and liability insurance as well, okay? That is a part of your bond condition as well. If we find that you're driving, you don't have insurance or any other violation, you will go to jail. No more PR bonds. Do you understand?
Yes, sir.
Now, you've got great lawyers. They'll take care of you because you have them. I will waive your appearance. You don't have to waste your time coming to court. But stay in touch with them and they'll tell you if and when you have to come back to court.
Yes, sir.
Judge, I'm sorry, I'm running this license. It's not loading right now. Okay, here it comes. Judge, the license is eligible.
Okay, great. So what we'll do for now is we'll have you go to Victoria Sign and Reset. You'll get with Roxanne for your bond conditions, and after that, you're free to go.
Thank you, Judge.
You speak English, sir? Yes or no?
Yes, sir.
Is there a Joya here? Joya? Sir, you're charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. Okay.
Just one moment, Your Honor. Judge, on April 21st, 2025 in Harris County, Texas, a law enforcement officer was dispatched to a shoplifting call at JCPenney and made contact with a complaining witness, a loss prevention officer. The complaining witness stated the defendant entered the store and selected a hoodie, removed an anti-theft sensor, and put the hoodie on. The defendant then exited the store, passing all points of sale. The defendant was detained by the loss prevention officer, and a pair of shorts and a t-shirt were located under the hoodie that were also not paid for. The total value of the stolen property was $100.
Shoplifting might look minor, but here's the lesson. Probable cause doesn't blink at the price tag. Whether it's $10 or 10 grand, once you're caught on camera, slipping merchandise under a hoodie, it's game over and at. Just 18, this defendant just got a tough intro to the adult justice system.
So like on a gray, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to go to any JCPenney. Do you understand?
Yes, sir.
If I find that you do, I will revoke your bond, put you in jail. If you pick up any new cases, if you're a danger to my city, it's not going to go well for you. How old are you?
18.
I'm going to appoint your lawyer today. What are you doing with yourself?
I'm going to school and I'm working.
Where do you go to school?
MacArthur High School.
Hey, I don't want you using alcohol. I don't want you using any weed. I'm going to test you today. Do you understand? If you do, it's not going to go well for you likewise. You mind reaching out to the man? I'm going to have you take a seat right over there, and I'm going to send you for a test. You were to come back. Do you understand, sir?
Yes, sir.
And then I'll have a lawyer for you. Please.
I guess we can talk about it. I got appointed to a case a little bit late, but he was already on it. So they reappointed him to this guy in custody, Jerry Birch. I might still be attached. That's what I'm approaching. But
I don't see anyone attacked. But regardless,
The issue, Your Honor, is we went over.
he's in jail.
He's in jail,
I'm
yes.
sure he's on bond.
But we want to roll it to tomorrow because
I think you had issued a warrant because he maybe missed a court or something. I don't know.
Okay, whatever you want. Sure, if you want to roll it, we can roll it to tomorrow.
All right, thank you.
Okay. And I have Lorenzo Lacona. You had sent him for a drug test earlier, Judge?
Coming up. Is that mom?
That is mom. Okay. Do you want to come to?
Not, I mean, I don't think she understands her. She speak English? Okay. Guys, what do you test positive for?
It was something positive for THC or benzo. Okay, well, we need to.
No, sir. No more. I'm gonna test you like crazy. If I find that you're using, what happens? That's right. Do you speak Spanish? Dime con quién andas, yo te digo quién eres. Don't be hanging around with the wrong people. It's not gonna go well for you. I want you to stay in school full time. I don't want you out, and I'm giving you a curfew, so you're not out in the middle of the night. 10 p.m. Do you understand? And I'm gonna test you weekly, so I know that you're not using. The next time, I'm giving you a 50-day pass on the weed. After 50 days, if you continue to test positive for weed, you test positive for anything else without a valid prescription, it's not gonna go well for you. Do you understand me?
Yes, sir.
You will not fall through the cracks here. Okay, thanks, counsel.
Now you do work and go to school. He works at Discount Tire. Is that good for you? As far as the curfew extend?
It's all good.
It's good? Okay. Just making sure.
Hicimos un examen de drogas y tenía positivo de marihuana y píldoras. Le dije que no más. Le voy a hacer exámenes cada semana para ver si está usando. La próxima vez se quede conmigo. También le voy a dar un curfew que no se puede ir de la casa de las 10 de la noche. Se tiene que quedar en la casa. Si él sale después de las 10, voy a revocar la fianza. Necesitas algo más.
Gracias por ayudarme.
¿Cómo no? Cualquier cosa que tú necesitas, me avisas y lo hagamos, porque no quiero que él se falle de más. No puede comunicar con la otra persona. Do you know who the co-defendant is in this case?
I do not.
Guys, who's the co-defendant?
Yes, Judge.
Like, is it friend, relation,
Oh.
brother?
Not sure.
I don't.
Stipulation.
So I told him no using drugs, no using alcohol. I'm getting him a curfew.
I don't know.
Guys, put a monitor on him, please. And no contact with the.
I don't believe there is a co-defendant in this.
No, there is.
There
There is.
There is. Just the dude didn't show up today. Si necesitas algo, avisas. Come on.
Yes.
Judge, are you fixing the curfew with the?
Yeah. Yeah. 10 p.m.
Okay.
10 p.m. So you have a lawyer.
Tienes un abogado aquí.
If you need
Si
anything,
necesitas cualquier cosa,
let the lawyer know.
déjalo saber.
If he starts misbehaving in your house,
Y esa comportarse mal en la casa,
you let me know
le dejas saber al juez
and I will take care of him for you.
y yo me encargo de él.
Okay.
Okay,
Okay?
está bien.
We're going
Thank
to put a
you.
monitor on him so we
Vamos
know
a
where he
ponerle-
is at all times and we don't want him out in the middle of the night.
Y no nos quedamos afuera
Target as well.
y no puede regresar al target. Va a tener un toque de queda, ¿entiendes?
Sí.
Okay? Okay?
Okay, gracias.
Thanks. Miss Washington, ma'am, you're charged with possession of marijuana. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, ma'am.
On April 21st, 2025, in Harris County, Texas, a law enforcement officer conducted a business check at a convenience store. Law enforcement officers observing surveillance saw two males engaging in hand-to-hand transactions and leaning into the passenger side window of the black sedan. The law enforcement officer made contact with the defendant, the driver of the black sedan, and observed marijuana in plain view in the cup holder of the vehicle and carried out a probable cause search. The law enforcement officer found a baggie in the cup holder to contain a green leafy substance identified as marijuana. The approximate weight of marijuana was 0.427 ounces.
Two males have a hand-to-hand transaction.
Yes, Your Honor.
They get into the car.
Yes, Your Honor. They're
Officer
speaking.
goes to the car.
Yes, Your Honor.
Where's she?
She's the driver, Your Honor.
She's the driver.
That's correct.
Ms. Washington, we're going to find that there's sufficient probable cause to go forward with the case. Can you run her license, please?
Yes, Your Honor.
Do Do you have the ability to hire a lawyer, ma'am? Okay, I can have you fill out an application. I'll take a look to see whether you qualify. I need to know everything about you, what kind of car you drive, what kind of income you have coming in, and then I'll take a look to see whether you qualify.
Eligible, Your Honor.
Okay, you're not allowed to drive unless you also have liability insurance, car insurance. You understand that is also a condition. I'll have Deputy Miranda give you an application. I'll have you get with Victoria for a reset, and then just take a seat for me and take a look at your application. Hi, Lori.
Hey, Judge, Mr. Mendoza, I got a plea. Francisco Mendoza.
Good morning.
Judge, he wants to show you his ID for where he works.
That's where I work, sir.
Great.
I've been out of
Out of trouble.
I've been snapping my hands.
He just got out of the mental hospital on day before yesterday.
All we want are our streets to be safe. And you need to understand that the type of case that you have now, the burglary of a motor vehicle, one of two things is if you continue, one of two things can happen. Number one, you're asking to get shot dead because people like their cars and they like their guns. And you mess with the wrong person, I can't tell you how many times we read of someone, something like this, they run away and they shoot them in the back. Really. When that happens, it's over. There's no coming back. Number one. Number two, if you continue with this type of case, they can hit you with a felony. And then you're looking at years instead of days. I'm just telling you of the possibilities. That's why you think.
That's why you need to think first. Because that's not just a judge. That's a one-man intervention team. He's laying out the hard truth. Get caught breaking into cars next time. It could be a bullet or a felony charge. This courtroom isn't just dishing out jail time, it's handing out wake-up calls.
Because when you don't, that's when you end up in jail. You see what I mean? You work hard, put your heart into it, you can do damn near anything in this life. You know what I mean? So you're charged with burglary of a motor vehicle. You've worked out an agreement. They're offering you 21 days in jail, credit for the 7 days that you've done. You need to understand that this is going to go on your record. It will be there for the rest of your life. Is this what you want to do? From now on, you're facing a minimum of 90 days in jail. You pick up another case. I'm telling you, it's a 90-day minimum from now on. You understand?
Yes, Your Honor.
You're giving up the right to a trial, right to compel witnesses to testify on your behalf,
Sure.
confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. So once you plead guilty, you can never change this. Do you understand? Is this what you want to do? How do you plead to the offense? Are guilty or not guilty? I'm going to find you guilty. I will follow the agreement, send you to it. Good luck, sir. Keep working, man. I'll roll your court costs so you won't owe anything. All right.
On
Thanks.
Mr. Rolock, he was sent down because I had reset him, but I did get in touch before he was sent down to his father. Can I bring him back tomorrow and get my
course.
Okay.
Whoa, you got to hold it. Go that way. You're good.
Right here.
You got to hold it, Dad?
Mm-hmm. His
Like,
stepfather. Yeah.
Real dad?
No, his stepfather. It's his baby brother's father.
Okay, is this the dude that he was talking about?
Mm-hmm. And I spoke with him. He said he would help him out. He gave me his address. I have his phone number. So I'll call him back today and tell him that.
And he can stay at that. He can stay at that house. Okay. Should we put a monitor on him? What do you think?
I don't think so.
I think tomorrow we can address the condition.
Yeah.
Okay. I definitely want to test him because I want to make sure he's not using. Take care, man. Okay. Yeah. Well, we'll talk tomorrow, Lori.
Okay, thank you, Judge.
So what are we doing?
This is the case that was transferred from court 16. It was put on the docket today. You already knew about it, but it's just that he's here.
We knew that they were going to file
Yes,
it, right?
uh-huh.
Okay. I think we already have conditions on him. Don't.
Judge, the new case that was transferred from 16, there's not even a bond in the system. So that's why.
I mean, I'm showing there's a $100 bond.
Are you looking at, let's see.
The 255-9015.
Right, but a bond wasn't posted. Instead.
Okay, so we'll give him another PR bond, and then all the conditions that we have now, we'll have on him.
Does he need to re-sign those conditions?
Yeah, he'll have to sign.
Okay.
We'll he'll have to sign for new bond too.
Okay.
So just don't let him leave. She's gonna call you up to sign a bunch of stuff, and then after that, you guys can get together. Okay.
I have Mr. Anderson on docket, Your Honor.
Ready?
I am ready.
Thank you, Mom.
And thanks for tuning in, folks. Catch you next time